Hi and welcome. I'm Karen Powers. I'm a seniors living and certified agent in place specialist. And today I'm here with attorney Ben Cote. Ben Cote practices three areas of law: estate, business law, and real estate. And I'll let Ben tell you a little bit about his firm. But I really would like to give him a big warm welcome because he's a trusted partner of mine. Welcome, Ben.
Hi, thanks for having me.
Yeah, I'm so glad we could
Uh,
do this. So do you want to tell
yeah,
us a little bit
same
about
here.
your firm?
Yeah, absolutely. So, my firm's called Cote Law Group. And so we have two primary areas of practice that we work on: estate planning and real estate. That intersects with most people. But we also do business law, and then we also offer family law. So things like divorce, guardianship, things like that. But I think the area that I focus most of my practice on would be considered estate planning. So I help people prepare wills and trusts, thinking about things like mass health, estate taxes, kind of working through some of those big issues.
Okay. Well, while preparing for this today, I did a little bit of research and I came up with some staggering numbers, which I was quite surprised by. One I found, and I'm sure you know this, that in the next 30 years, it says that American retirees will be transferring $36 trillion to family, friends, and nonprofits.
Wow.
And with that number in mind, I also read, and you can tell me your experience with this, that 67% of us do not have any estate, 67% of adults in the US do not have any estate plans in place. So, what is going on? What do you
Yeah.
think?
And that number, so that's the scientific number that they did a study, and that matches up with my personal experience of the vast number of people that don't have any sort of planning in place. Um, so I think we're starting to see the beginning of that. They call it the great wealth transfer. We're starting
Hmm.
to see the beginning of that in my practice. And it's really interesting. So there's opportunities where we can minimize taxes on that transfer. There's opportunities to avoid family division. There's opportunities to make things really simple and easy for loved ones. And I think we're going to start to see more focus being put on how do we actually plan for this transfer to happen. It's becoming more of a reality, and it's easy to understand why people don't want to deal with it. You don't want to talk about mortality. You don't want to go
Hmm.
through the hard work of making final decisions. It's generally kind of unpleasant to think about your own demise, but ultimately, it's really critical. It's important for the person that is transitioning, but also their family. So it's something that everyone should really think about.
Yeah, absolutely. So, I mean, so I guess getting into the basics, right? I guess a lot of people don't even understand. They think, oh, I just need a will. Do I need a trust? Do I need both? Can you shed some light on that if people need both or what the difference is on the two?
Yeah, absolutely. So the first thing that I'm always thinking whenever somebody comes into my office is, what if we did nothing? So
Hmm.
doing nothing is a valid option for estate planning. And so when somebody passes away without a will, they're said to have died intestate, which just is the legal phrase for no will. And so that is an option for some people. If in rare instances, I'll recommend it. Somebody doesn't have a lot of assets, they don't have any real estate, maybe they have one child, there's no dispute about who's getting what. In that case, maybe not having a will is okay. But for the vast majority of people, having a will in place at the very least helps to make sure that your assets are going to the right people, that you have the right person or people making decisions for your estate. A trust is a little bit different, so that's a separate legal document. One of the primary benefits is that we don't have to go through the probate process in the probate court.
Hmm.
So what I've found is that for a lot of people, a trust is a great option, but it entirely depends on what a person's goals are. So no two clients that come in my office are the same. They have very different goals. They have different assets. They have different health. They have different families. So one of the tough parts about estate planning is it's so customizable and so broad that a lot of
Hmm.
people get paralyzed by that decision making process. How do we actually make decisions when we have so many different options?
Yeah. Yeah, I feel the overwhelm myself just thinking about, everyone. I think people try to think like, what's the right way, what's the wrong way, and then they might listen to family and friends. I think they're afraid to make that first step, maybe to come into the office and to meet with an attorney, right? But I think
Yeah.
you don't you offer a consultation, don't you, initially to help people?
Yeah, absolutely. So we offer a complimentary consultation. Our thought process is people come in, they get to know us, they can learn a little bit about what the basics of the different tools are. And then we can start talking about how to apply those tools for their individual situation. And so I usually what I'll do is I try and rip the band-aid off. I talk about the hardest part first. And
Mhm.
so I'll jump right in and I'll say, all right, where do you want your assets to go after you pass away? If they have minor children, I'll ask them about guardianship. So who's going to take care of your kids if you're gone? If the people that you want to leave your assets to, if they're all gone, where do your assets go? And by the time people have been in my consultation for 5 to 10 minutes, they've answered the hardest questions. I can
Mhm.
kind of see it on their face that they have a weight lifted and they go, oh, this wasn't so bad. I'm through the worst part. And so it can be a little overwhelming. People don't really know what to expect. Do I need to bring all my documents? Am I going to be judged because I don't have everything set up neatly or all organized? Is my family going to be an issue? Those are all things that every single person deals with. And one of the things you mentioned was, am I doing the right thing? What is the right option?
Mhm.
And kind of like what we were talking about before, there really often isn't one right option. And so, what I've found works really well is ask people what they want to do, and then I'll give them kind of my rough estimate of what percentage of people pick that option. So, we might say, um, uh, if one of your children passed away before you and they left children of their own, would you want your grandchildren to receive their share of the estate? People often say yes. And I go, okay, perfect. That's about what 90% of other people tend to do. So I like to kind of give some of that context so that people know that they're not doing something that's completely unusual. And I'm not afraid to tell people what you're doing is kind of unusual and some of the reasons why they might not want to do it. So my job in the process is to give people options, tell people what is common, what's less common, and then just help them try and get to whatever their end goal is.
Right. Well, which makes sense, right? And I think you're a good listener, which I think you probably need that skill set to kind of, like you said, peel back the layers to see what people really need and what they're thinking about. So, tell me, can you explain the difference between a revocable and irrevocable trust? Because I think people get jammed up on that too. They don't really understand the difference between the two.
Sure. So a trust, just kind of by way of background, is a legal entity that we create during a person's lifetime. You can think of it like a bucket. I like to think of it like a safe. And so
Hmm.
there's two types of safes. One where the door remains unlocked, so we can put assets into it to protect them. But the door is unlocked, we can open it back up to take the assets out. And that's what I would consider a revocable trust. An irrevocable trust is a little bit different. That's almost like one of those old school drop slots where you drop your check or you drop your keys at the mechanic or whatever. Once you drop it in there, you don't get it back. And that's
Hmm.
more along the lines of an irrevocable trust. So irrevocable trusts are nice because we can get some creditor protection. So if we're worried about nursing home liens, we're worried about potential lawsuits or divorces in the future, we can basically protect those assets from those dangers. The downside is we can't get them back out of the trust. So we can't change the trust, it's irrevocable, and we can't actually access the assets as the person that creates the trust. And so for some people, makes a lot of sense. We want to protect against nursing home costs. If that's the number one goal, we want to make sure we're maximizing the inheritance. Irrevocable trust can be a really good tool. For other people, they might say, you know what, I really want to be able to access the equity in my home and the other assets that I have through retirement to make sure I'm living a really good quality of life. I don't want to lock up those assets. That's totally reasonable and very understandable as well. So it all circles back to where are we trying to go? What does our end goal look like, and how do we work backwards from there?
Okay. Yeah. So now tell me, I hear, I've seen a lot of things, recently on the internet, people talking about, having an adult child on the checking account or savings account with the parent, and why that can be a good and bad idea. I mean, what kind of protections are in place for that if someone does have that in place?
Yeah. So I have that. People come to me quite often and say that they're either planning to do that or they've already done it. Uh, I don't think it's necessarily a bad thing, but there are some risks to consider in doing that. The
Hmm.
first risk is, of course, that by having another owner on the bank account, that person can go to the bank and withdraw the money. So, for most of us, we don't name our adult child as a co owner if we think there's a risk that they're going to steal from us. But
Hmm.
it does happen. It's statistically possible. even if it's unlikely. The other risk to consider is that that person's creditors are now your creditors. So if I have my child listed as a co-owner, that child gets into a lawsuit where they lose. That plaintiff that's suing them is going to start going after that joint account. And it's not enough for me to say, oh, well, this is just for estate planning. This was for convenience. It's not really their money. The court won't look at it that way. And then the third possibility is bankruptcy. So if your child who might be financially stable now, who knows, 5 years from now, maybe they lose a job, they have a catastrophic medical issue. It's at that point that the money, if they file bankruptcy, could be used to pay creditors as part of that bankruptcy. So those are things that a lot of my clients don't tend to think about, but there are definite risks. And I've had people listen to them and say, you know what, I'm okay with those risks. They're unlikely to happen. I like the convenience of having a co-owner on the account, but I think there are better tools we can use. We can use a trust and we can use a power of attorney. And both of those would allow access. Well, in the case of a power of attorney, it allows access during your lifetime, and then the trust would allow access after you pass away.
Okay. Oh, yeah. So that's an interesting point you just brought up about the power of attorney, because I think people get confused about that of when it ends, and then the other thing, back to the money piece of it, right? Some people are like, well, I don't want to give so and so power of attorney because when we were growing up, so and so had power of attorney, and we heard this terrible story that they took all the money from the parents. So can you shed some light on that, the truths? And
Absolutely. Yep. So the power of attorney, I like to say it lasts as long as you do. And so the power of attorney becomes invalid, or it can no longer be used once the principal, so the person that signed it, passes away. The good part about a power of attorney is that it creates a fiduciary relationship. So the person that's actually using the power of attorney for your benefit owes you a duty of care. So they owe you the duty to account for what they've done. They owe you a duty of loyalty. They owe you a duty to put your interests ahead of their own, which essentially means that if there was a breach, at least in theory, somebody can vindicate that breach or vindicate your rights by going to court. That can be expensive. So it is important to make sure you pick somebody that you trust. You want somebody that you would trust with money, trust with sensitive financial decisions, trust with being a good communicator. Probably the most important skill that's overlooked is being able to communicate with the other family members. Somebody that's open and forthright and honest and says, this is what the plan is, this is where we're going, why we're going there. That goes a long way. And if the person that's named as the power of attorney was named just because they're the oldest and they tend not to communicate with the other family members, that's where we see a lot of disagreements that end up in court.
Okay. So how do you help people stay out of court then with the probate?
Yeah, so probate in particular, we can stay out of court by using a trust. So unlike a person, a trust doesn't die. And so we just look at the next trustee, the next beneficiary, and that tells us who has authority to sell assets, who has authority to invest them, and where do they get ultimately distributed. I find that for a lot of people, once we're in the probate court, it's much more likely that we're going to have legal challenges. And that's simply because the court sends out a notice as the first task that says, if you object, you have 30 days to file it, or else you lose that right to forever. And I think the knee-jerk reaction for a lot of people is, I don't know what to do. I'm going to file and see what happens. And so we end up with a lot of disputes, which they can last 2, 3, 4 years, depending on the types of factual, the types of facts at issue. We saw kind of a long delay through COVID. The court system was in a really tough position to kind of get through cases, but we're still unwinding a lot of legal issues that have taken years to resolve, that if they were in a trust, we probably wouldn't be there.
Right. Yeah. So financially, right, that's impacting people financially, right? Because I heard probate's very expensive, and you said sometimes 2 to 3 years. And so they could have saved a lot of money, right, if they had the trust set up.
Yeah, so I would say the average probate is anywhere from $6,000 to $10,000. The average cost of administering a trust is much lower. For some of these multi-year legal disputes, we're talking about probably $30,000 plus in terms of legal fees. And it's not like we're working on it every single day, but whenever you travel to the court, you go to depositions, you're reviewing discovery, you're negotiating with the other side, and then do that sort of cycle every 3 to 6 months, it adds up.
Yeah.
So there's considerable savings to be had by setting up a trust, and it usually results in greater harmony for the family too. Because I like to remind people that the most important thing in their lives is probably not their money or their house or the stuff that they have. It's about the relationships with their family members. And if we want to make sure that those relationships last beyond their passing, we want to be really careful about how we set things up to make sure that we can avoid disputes if we can, and make things as easy and collaborative as possible.
Yeah. So tell me, how do we get people into you? Because if we're seeing 67% of adults don't have anything in place, one, how do we get them in? What age do you feel is like the typical age, and what age are coming in, and what age do you think people should really be putting this in place?
Right. Well, there's a couple typical ages, or maybe three. The first is somebody has their first child. It's very common for somebody to come in, set up guardianship paperwork, set up a basic will, or I actually recommend a trust. I think they're very important for people with young children.
Mm-hmm.
Because we can manage the money beyond the age of 18. The other common age is somebody that's gearing up for retirement. So maybe they're late 50s, early 60s, and they say, I want to have my financial house in order. I want to make sure everything's set up correctly. And then we'll have people that are maybe a little bit deeper into retirement, that they've maybe had some health issues, or they're starting to feel the need to make these sort of arrangements. But there's really no wrong time to do it. Even if you start with something like a will, or even without a will, there are plenty of people that come in and they just want a power of attorney and healthcare proxy. And I think that's great because it makes sure that they're taken care of should something happen to them. And we have other clients where they'll come in and their dementia has progressed to a point where they can't sign legal documents, and now we're forced to make a referral to an attorney that will help them with guardianship paperwork in the probate court, which is going to cost $5,000 to $10,000 and take months. Is a public facing process, is very difficult, and it takes a long time to get appointed and actually help the person. So some of these simple tools that we can start now can make a huge difference down the line.
Yeah. So tell me, you just mentioned people with dementia or cognitive decline. How do you determine that? Do they come in there with like some type of paperwork from doctors? How does that work?
Yeah. So doctors can make a determination that the person is no longer able to make medical decisions, so they'll actually activate their healthcare proxy. But dementia, I'm sure you've dealt with this with the type of work that you do. It's not a 1 or a 0, black and white, yes or no type thing.
Mm-hmm.
It's shades of gray. And so on one day, a person might come in and I wouldn't have even thought anything of their condition. They have good recollection. They understand who's in their family. They know what they own. They know what the effect of the legal documents are. And then there are other days where I'm talking to a potential client or a client, and I'll tell them something at the beginning, and then I ask them about it at the end and say, okay, so we're signing paperwork today. What does your will do? And they're unable to remember why they're even sitting in my conference room. And so not usually, I'm always making a determination when somebody's signing a legal document whether they have what's called capacity. So capacity is the legal definition or the legal requirement of what you understand or how you understand it in order to sign legal documents. And in the case of a will, they need to know who's in their family, what they own, the legal effect of the document, and that's the necessary ingredients for them to sign. So that's a long way of saying I'm trying to make the best judgment I can, take notes if there's a close call, to be a good witness should something come up in the future. I can say, well, we talked about this, we talked about that. These are the things that animated their decision, why they did a certain thing a certain way. And that's an important part of actually going through with a signing on an estate plan like this.
Okay. Geez, we've covered so much today. I mean, there's so much, I guess, information, and I think that's why I feel like people get overwhelmed. But one other thing that you brought up that I wanted to touch base on was the healthcare proxy, because I don't know if people know the difference between that and I think it's HIPAA in terms of giving other people access but not making decisions.
Right. Yeah. So healthcare proxy is a document that says if I'm unable to make medical decisions for myself, I want this person to make them for me. One of the things that I've found with healthcare proxy forms from doctors' offices is that they'll often not have a backup named. And so you might name a spouse that's very similar age to you, similar health issues. You might name a sibling that's a similar age to you. And what will sometimes happen is we go to dust off the healthcare proxy and it's somebody that also can't make medical decisions. So having that plan in place where we have the primary and then we have some backups is really important. The HIPAA authorization is a little bit different. So that is actually authorizing your medical team to share medical information with your family. And that helps us for a couple of reasons. One, it helps with making medical decisions. It allows communication to flow more freely. But probably the more useful thing from an estate planning perspective is that the trustee of a trust, or let me take that back, the backup trustee of a trust can go to a doctor and say, I think the primary trustee has dementia. Can you tell me if there's been a clinical diagnosis so that we can make the moves we need to with having a new trustee put in place? Without the HIPAA waiver, the doctor is under a legal obligation to say, I can't talk to you about my patient's chart. With the HIPAA waiver, they can say, yeah, they've been diagnosed with mild cognitive impairment or early onset dementia or whatever the case may be. And it gives the trustee some flexibility and some insight to make their next move, which can be really helpful.
Yeah. No, that's like really important information that I don't think a lot of people would probably, think about. So that's great that can be done, because I can just see that being a real issue with people, especially today, because I feel like there's more and more people having cognitive decline earlier rather than later, which is another whole, scary topic for people. So what would be, like, for today, what would be your best advice for people that don't have anything in place? Like, at a minimum, what could they do if they're not ready to take that leap?
Yeah, so I would recommend, even if you have no intention of signing paperwork, I think it's a good idea to talk to an attorney about what your options are. Because some of these decisions, maybe you're not ready to make a choice, but at least if you have some of the language and some of the concepts that you need to make a choice in the future, it'll give you time to kind of think things over. In terms of tools to have in place, I think a power of attorney and healthcare proxy are important for everyone. So having that in place can be very helpful to both you and your family should something happen, and they're very affordable just as a place to start at. So if there was one thing I would say, if you do nothing else, power of attorney and healthcare proxy are a good place to start.
Okay, well, that's good. So this has been all very helpful for everyone, I think, today. I would love to do like a future webinar with you so that we could get some questions in from people that you could answer, because I'm sure that people that are going to tune in today to watch this will probably, have questions that they're going to think about. Kind of like when we're talking, my mind was going with, tons more questions, but I don't want to confuse people with my questions. That so tell us how people can get in touch with you. What's the best way to get in touch with you?
Yeah, the best way to get in touch with us is to visit our website, which is cote-law.com. And then you can either visit the website, there's an online form where you can actually schedule an appointment, or just call us at our number, which is 781-761-2148. Talk to somebody in my office and they'll set up a complimentary consultation. We don't do any sort of high pressure sales techniques. We're basically there to teach people about what the basics of estate planning are, talk about some options, and if it's something that we can help them with, we love to do that. But it's really easy. Just visit the website, reach out to us, and we'll take care of the rest.
All right, that's great. And I personally have sent many clients and have used you personally, and I can attest that you're a very caring individual with a great team that listens and really does the best for their clients. So I'm happy to be able to give that testimony to people in review. So
thank you. You're making me turn more red than usual.
Oh yeah, stop it. Well, this has been great, and I look forward to talking with you more in the future.
Yeah, same. And I'd love to do that webinar you were talking about. I think that I really enjoy talking to people. As you can tell, I kind of geek out on this stuff. So I'd love to do that.
No, and I think it would be great, because I think sometimes people just can't get out, but if they know, if they can, like, even, younger people with young families, what have you, be like, okay, I'm going to go now and have someone else take care of the kids, that they can do that versus running out of the house. So sometimes I think the online things work a little bit better, to
Right.
get to people. And they can ask
Absolutely.
questions anonymously too, sometimes,
Yes.
which is even better.
Yeah, that is good. That's actually my favorite part. So I'll do presentations. I actually did a presentation last week at the Situate Senior Center. It was about an
Mm.
hour. It was great. We had a PowerPoint, but I asked people, just raise your hand, interrupt me in the middle, just ask me as many questions as you can. And it was super interactive. People, there must have been at least 100 questions. And it's my favorite part. Um, so
Oh, wow.
um, I'd invite anyone, if you have a question, just shoot it on in and we'd be happy to answer it.
Well, that's great. Well, thank you again, Ben. I appreciate your time today.
My pleasure. Thanks for having me.